So let's get started. Chapter 31, we're going to start with, before we get started actually on these different laws, let's just talk about employment. So there is this notion with the employer-employee relationship of employment that lasts as long as both parties want to continue with employment. And that concept is referred to as at-will employment, right? Employment is at the will of both the employer and the employee. And that sounds pretty good. I mean, that's, we talk about contracts as being voluntary relationships. Well, so is an employment relationship, right? An employee shouldn't have to work for an employer if they no longer want to, and an employer should not have to keep an employee on if that employer doesn't want to do that anymore. And that's where the term at-will employment comes from. So, yes, an employer can discharge or let go of an employee if they choose to. But the problem here is that, and we'll talk much more in the chapter 33 about, what if that employee is being let go of for an impermissible purpose, right? What if it's discrimination of some sort? Well, the employer doesn't have the right to do that, and in fact, the employer can be sued if they do that, right? So, think about employment as mostly being at will, but there are exceptions to that as well. I mean, for example, some people have employment contracts, right? What if an employer hires somebody at a high enough level that they want to keep them on for a period of time? Sure, they can do that, and there, when you have a contract or an agreement, there is usually a term within which if either party were to break that employment contract, there could be consequences, damages, and so on. But, we don't think about employment contracts for the vast majority of the workforce. The vast majority of the workforce will have at-will employment. But again, if we're talking about some higher-ups at companies, if we're talking about athletes or things like that, there is an incentive on the part of the employer and the employee to sort of keep that relationship going for some period of time. Okay? So let that sort of percolate in the back of your heads about what the employer-employment relationship is. And now let's get started on the various laws that might apply. The first one, when we start on the slides, is the workers' compensation laws, right? Everyone knows workers' comp. Hopefully people haven't had to take advantage of workers' comp, but workers' comp is really designed to provide compensation. Compensation for what? Compensation for any work-related injury, and it's only work-related injury that happens to the employee, and to the extent that the employee's family is affected, if the injury is severe enough, then there is compensation contemplated for that as well. Well, how does workers' comp work? Well, workers' comp works when an injury is reported to the employer and to the appropriate state agency. The claim is filed. That workers' comp agency within the state, and this is mostly state-based law, will look at whether or not the claim is legitimate. Did the injury really happen at work? Is it the kind of injury for which compensation should be given? And then, whether it's continuing pay, whether it's a lump sum that's paid depending on what type of an injury it is. Most people sort of think of it as workers' comp, well, I slipped and fell. Or I got, I was working on a factory line and, somehow I injured myself. My finger got stuck in the machine, or whatever the case might be. I mean, it could be severe, it could be, not so severe, but whatever the case might be, workers' compensation is designed to it's sort of an insurance program to deal with that and kind of have a way to pay out compensation related to work-related injuries. Now, you might say, well, where does the money come from? Do employers have to set aside a pool of money for any potential injury that might happen? Possibly. Employers can choose to do that. So if we look at the next slide as to what states require employers to do, and you'll see in this chapter that, employers are expected to do quite a bit for their employees, not just pay them wages, but to, as we'll see, to have some mechanism to pay out on workers' compensation, to provide them, with health insurance, they're not required to, but if they do, there are rules, relating to that, to provide a safe environment, to provide, leaves and so on and so forth. So these are all obligations on employers with respect to the employment relationship. Yes? Mm-hmm. The agency is a state agency. It's usually a workers' compensation board. It can be known by various different names, but it is a state office for lack of a better word. All right, so back to this question about what do employers do in order to fund a workers' compensation pot of money to pay out if the need be. Well, most employers will just buy workers' compensation insurance, and the state agency, the Workers' Compensation Board, basically has a state-run fund. So most employers will just pay into the fund. If I have, 100 employees working for me, I'll pay X cents per employee per month, pay into the fund. Hopefully, my employees will not get hurt, but if they do, there will be a pot of money at the state level that is used because employers are funding this on an ongoing basis. It's basically insurance, and that's what most employers do. In fact, that is what they are required to do under state law. But if an employer is large enough, and if you look around in New Jersey, we have some very large employers, big pharmaceutical companies, big financial companies, and so on. A lot of employers will say, well, wait a minute, why do I need to pay per employee a sum of money into some insurance fund out there? Why can't I just self-insure? Meaning it's actually economically better for me to basically pay out of pocket to the extent that these injuries happen. So that is referred to as self-insurance, that a large employer can just choose to pay out these claims if they want to on their own, right? But regardless of how it happens, every employer has to sign up with the state agency, the Workers' Compensation Board, and say, either we will pay into your system, or look at us, we've set aside a fund and we will pay out on workers' compensation, even though it might be the state agency that is actually looking at each of these claims and determining whether or not an employee is entitled or not entitled, but the money actually comes from the employer if they're self-insuring. So that's just some extra information in terms of how workers' compensation works. Now remember, we said that these injuries to be compensated out of workers' compensation have to be work-related or employment-related. And we talked a lot last class about agency law, right? What does it mean to be within the scope of employment? And we saw that most courts would look at it as being pretty liberal, right? It's not just necessarily being on the employee's premises, but to the extent that an employee may be commuting to work, if they're a salesperson or something like that, that might still be a worker compensation and injury. And in fact, we're going to look at case law in a minute that really defines that the scope of injury doesn't have to be necessarily on the job. It can be at a work-related function, right? So, and what kinds of things can someone get compensated for under workers' compensation laws? Well, usually it's a physical injury, right? I slipped, I fell, something happened physically to me that requires me to get medical attention. I can't work anymore. Yeah, we would expect those are the types of injuries that workers' compensation is designed to compensate for. But if you look at the fourth slide, in addition to physical injuries, we also see things like stress or mental illness that is employment related. And this is sort of, the law evolves over time, and there are claims being made of certain employers that, the working conditions led me to not have a physical injury that you can see, but the kind of emotional, those are hard cases to prove, and some of them may be frivolous, and people sort of, push the envelope, but some of them are quite legitimate as well. So I do want to make the point here that workers' compensation is not necessarily, although vast majority is related to physical injuries, but one could make an appropriate case for an employer perhaps discriminating against an employee to such a degree that it caused that employee to have a nervous breakdown or some, and if you can link that to a job-related kind of a situation, it is possible that that could be a compensable injury under workers' compensation laws. All right, so let's talk next about what happens if someone files a workers' compensation claim. Are they also allowed to sue their employer? What if someone injured themselves at a work site, filed for workers' compensation, got a lump sum and said, well, wait a minute, I can also sue my employer because they were negligent, for example. Can you sue the employer as well as get workers' compensation? Well, if you look at the slides and if you've read the book, the answer typically is no, because what they say is workers' compensation is an exclusive remedy. Meaning what? Meaning you have to pick and choose. And if you claim workers' compensation, you generally cannot sue the employer in court, except, right? General rule, but there's always almost an exception. The exception is if the employer's actions in causing the injury were intentional. Intentional, meaning, somehow the employer didn't provide negligent conditions, but they actually willfully, in bad faith, cause those injuries, and that's rare, right? I mean, employers may have not serviced their machinery when they needed to, and that's what caused the injury and so on. That's not willful, that is not intentional, that is negligent. So if you get workers' comp, you can't sue your employer at the same time. But what can you do? Well, the slide 5 also says that workers can sue third parties to recover for injuries. So for example, take that scenario where, let's say, someone is working on a factory line and gets injured using machinery that was manufactured by some company that actually negligently assembled it, right? That individual has the ability to file for workers' compensation, where they're going to get compensation, hopefully, for this employment-based injury, but they will be able to sue third parties, not their employer, but this manufacturer of this machine that actually caused them the injury. So it's possible to sue third parties, but you cannot sue your employer if you're also claiming workers' compensation. Yes, question? Sure. How big is the company? Employer? Okay. Okay. And she claimed workers' compensation. How big is the employer? You don't have to tell me who it is, but how large is the employer? Okay, so it's a large employer. It's not okay. Well, that's yeah. In case everyone didn't hear, so the young lady works for a human resources department, and the hospital employer had an employee that slipped and fell, and obviously that's work related. And the issue here is that she's claiming workers' compensation, or has filed a claim, but at the same time has also filed a lawsuit. And we don't know the basis of it. I mean, the lawsuit could allege that there is some intentional right. And maybe this is a claim not just against the hospital, but against the city as well. So yeah, I mean, so who knows exactly? But it's an interesting sort of a scenario. But the bright line rule is that an employer cannot both be responsible for paying out on a workers' compensation claim and for that same accident, unless they were intentionally involved in causing that accident, also have to pay out on a lawsuit. Sure. From whom? From the employee? Yes. So the question is, what if the injury is intentional? The employer actually intentionally caused harm to the employee. Could they get additional compensation? Not from workers' compensation. Remember, workers' compensation is adjudicated at the state level, but an employee can file a lawsuit later. There's statute of limitations that are pretty liberal in that area. And yes, it is possible, if they're successful, to get additional compensation for a tort, right? A tort of intentional harm if they're successful. But rare, because I mean, imagine a situation where the employer is intentionally causing an injury, and it's not likely to be in the vast majority of cases. So let's talk next about the Coca-Cola case. This is Kelly versus Coca-Cola, Court of Appeals of Ohio, a 2010 case. And the question here is this individual entitled to workers' compensation? And in order to understand that, we need to know a little bit about the facts of the case. So who wants to do some talking? Coca-Cola? Was everyone so burnt out from the exam that they forgot to read the chapters? Yes.
I don't know if I completely understood it.
Sure.
But I noted it was about an off-site
Retreat.
retreat or something. They went canoeing, and
Right.
after they went canoeing, they were horsing around in the playground in the parking lot, and the upper management was trying to pull one of the guys into the river because they were throwing people into the water. And when he did that, he slipped and fell and hurt himself, and he was trying to blame it on get workman's comp because it was at a work function.
And the employer was pushing back.
And the employer was,
Right. And what did the court say?
and that they were doing outside of work.
Right. 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 And yeah, and it went to the Court of Appeals. So let me, yeah, and that's a good job in summarizing the facts of the case. I mean, so this is a large company that, sometimes just for team building or whatever, sort of reason that there might be, the employer organized an off-site kind of a fun event, and it was canoeing. So an employee, along with their supervisor and so on, are out, and the employee, Kelly, finishes the canoeing and is about to go home. And while he's waiting at the bus stop to pick him up, or the shuttle or something like that, his boss or co-workers or whoever sort of come by, and they're just sort of needling him. They're sort of clowning around, whatever. And I mean, it's not clear from the facts of the case that we have in the book whether or not he's resisting or not resisting, but whatever the case might be, this leads to an injury. He tips over and he actually injures himself. And the question is this work-related? And at first blush, it's like, well, wait a minute. On a weekend, being out and about, and even especially when the actual activity, you could almost say, has ended, you're on your way home, is this quote-unquote work-related that you can actually file a workers' compensation claim? At least there is that question that the court sort of has to look at all of the facts. And here we have an intermediate level court, the Court of Appeals of Ohio, says, well, looking at all the facts of this case, most reasonable people would say that a work-related event is something that employees are expected to go to, encouraged to go to, right? So the employee is doing just that. The employee is waiting around. I mean, the event really hasn't ended until they leave. It's still sort of happening. And now you're being sort of, nobody intended this to happen. It was negligence. But your boss is sort of needling you, whatever the case might be, and you fall. I mean, how could that not be work-related? You're not there because maybe you want to be, but you're not there because you chose to be. It was something that was asked of you. It was something that was encouraged of you. And courts are willing to go a little bit further in defining what is quote-unquote work-related. And it does lead into these kind of cases of these retreats, or even being out to dinner. Think about it. I mean, what if there's a Christmas party or something like that? And then there's a lot of liability that employers sort of have to think about because they're asking employees to come. They're encouraging them to come. And most courts would say that this is work-related within the scope of employment and so on. So, we talked under agency law of what if the employee injures somebody? Yeah, there could potentially be liability on the employer based on vicarious liability, but there could also be liability for the employer if the employee himself or herself suffers an injury with respect to a potential claim under workers' compensation. So the question is, cutting to the chase, and which is, okay, we're talking about compensation. How much? I wish I could answer that. I'll tell you what it typically is. Typically, workers' compensation is designed to not be the kind of big number lawsuit type of things that you would get in damages, but it is designed to do a few things. Number one, it is designed to provide wages for the time that someone is unable to work. It is designed to cover medical bills, and there is sometimes, in the appropriate cases, a lump sum kind of above and beyond, but it is nowhere near the levels of what courts might give out in damages. So yeah, it's wages, it's medical bills, and in some cases, it could potentially be a lump sum at the end. And again, it's an area unto itself. We could talk about many more facets of workers' comp, But again, as I said, this chapter is all about understanding the various laws that apply to an employment situation. And the next law that we're going to talk about, and most of the laws that we're going to talk about, are federal laws. So the next law is the Occupational Safety and Health Act, also known as OSHA, right? We like acronyms for everything. And the purpose of OSHA is to promote a safer workplace. And who wouldn't want a safe workplace, right? I mean, think about all that snow and ice that we've had, right? The employer's responsibility to clean up the parking lot, to provide, heat, to provide a safe and inviting environment for people to come and work there. So what does it require a typical employer to do? A typical employer is supposed to not only keep a safe environment, but also to keep records of what they've done, maintain safety. I mean, something simple as when was the last time that you changed carbon monoxide batteries or things like that? And are there fire extinguishers where they need to be? Are the stairs kept in good working conditions? When was the last time that the elevator was serviced? These are all, you don't just have to do it, you have to keep records of it. You need to make sure, and someone said they work in human resources. Part of human resources obligation is to keep these records. So if OSHA, the federal agency, comes in and wants to see records going back a few years, you have to produce them. And if you haven't, that's a problem. That's a problem in terms of penalties. It's a problem in terms of whether or not you can keep your doors open because you're being monitored. So again, we talk about what employers' obligations to their employees are and what consequences that has in terms of building that in to the cost of doing business, essentially. The other thing, and who works for a large employer here? A larger employer, let's just say, someone with more than 50 or 100 employees, okay? Is there a lunchroom? Is there a cafeteria of some sort? And do you kind of come across a big bulletin board somewhere where they have a bunch of notices? And maybe people read them, maybe they don't, but you're required to post in common areas. And it doesn't have to be a lunchroom. It could be, when you get out of the elevator, there's like some sort of a bulletin board. And it has all kinds of notices. It might have an OSHA notice. You're telling employees what it means to have a safe workplace. Other types of notices. For example, we'll talk about the family and medical leave in a little while. What are your rights? So these are sort of posters and things that are available on government websites that employers are required to post in an effort to inform employees what their rights are and what the employer's obligations are. So notices, record keeping, all of this adds up to a compliance obligation that employers have under the law. So talking a little bit more about the Occupational Safety and Health Act, OSHA, well, I mean, we're talking about a federal agency that is overseeing employers. Well, employers do not all do the same thing, right? I mean, there are medical offices, there are hospitals, there are factories, there are mining companies, there are accounting firms, right? How do you come up with rules and regulations that define what safety is for a typical employer, right? So yes, every employer should have fire extinguishers and so on and so forth. But if you operate a certain kind of business, well, your safety responsibilities go above and beyond. What are you supposed to do if you have a factory line? What are the responsibilities in servicing that particular type of equipment? What if it's a mining company? Again, you're not talking about a office building. You're talking about something far more complicated and complex. So the point here is that there are regulations that apply across the board, and there are regulations that are very specific to the type of industry. Think about airlines, think about transportation, and so on and so forth. So when we talk about giving employees a safe work environment, depends on the industry. And the same employer could be running a factory, have an office building, could have multiple work sites. And so we're talking about a large compliance area that needs to be monitored, that needs to be serviced, that needs to have kept records and so on. So you start to see a theme here in terms of what the employer's overall cost of doing business is. And slide 9, and I'm sorry again about the slides not being visible. We'll see what we can do during break. But slide 9 talks again about things that I've already sort of hinted at, that there are specific duty standards under OSHA, and there are general duty standards under OSHA, right? Every employer of a certain size, again, is supposed to keep a work environment that is free from known work hazards, right? You know, make sure that, again, the heating, the plumbing, the fire extinguishers and things like that. But if you're in a specific kind of industry, you really have to go above and beyond and make sure that your workers are protected in the type of equipment that you're using, that you're giving them the right type of safety goggles and things like that, because all of that plays into what your federal requirements are with respect to keeping your employees safe under OSHA standards. All right, marching forward, slide 10, another federal law, the Fair Labor Standards Act, the FLSA. And again, large employers that are subject to this are employers, you know, usually an employer that is of, you know, of reasonable size is going to be subject to all of these laws, are supposed to, again, put up notices. What are we required to do under the Fair Labor Standards Act? And by the way, the Fair Labor Standards Act is now, 70, 80 years old. It was enacted in the 1930s. And what it does is it regulates 3 key areas. Number 1, again, slide 10, is that it prohibits child labor. And we almost take that as granted, right? But it establishes minimum wage requirements. If you wondered where minimum wage came from in the first place, it comes under the federal law known as the Fair Labor Standards Act. And number 3, it establishes overtime pay requirements. And this gets a lot of people sort of thinking, overtime? I'm entitled to overtime? I never knew that. Depends. Not for everybody, but it requires certain types of employees to be paid overtime if they work a certain kind of job and certain number of hours. So let's talk about all of these requirements under the FLSA, the Fair Labor Standards Act, a little bit more. Child labor, right? Shouldn't be. I mean, you know, we sort of think about a lot of the headlines that sort of come about with a lot of U.S. companies sending their goods to be manufactured overseas, and, you know, who really works on those goods, and are we talking about oppressive work conditions, and even more sadly, are we talking about child labor being used? But here in this country, there is an absolute prohibition against oppressive child labor, which means various things. I mean, those are defined. I mean, how old does an individual need to be working in any capacity? And number 2, what are the kinds of conditions? You know, how many hours, breaks, things like that. So there's a, you know, please don't memorize this, but it gives you an idea on slide 12 about what the ages are. How old does someone have to be to get some type of a job? And under 14 can't do very much other than perhaps deliver newspapers. It used to mean a lot more when things were not digitalized, but who really gets newspaper deliveries all that much anymore? But anyway, you know, some of this is sort of historic. But then we start to see that teenagers can work. And the question is, how much can they work? And again, the slide just gives you a flavor that if you're under 16, an employer cannot hire you for a 40-hour work week. They can hire you, but your hours have to be limited, and they have to be what are referred to as non-hazardous jobs. And again, even until the age of 18, you could actually work all kinds of hours, but the job responsibilities still have to be non-hazardous. And above 18, yes, there's going to be all kinds of safety protections, overtime pay, minimum wage, and all that, but those individuals can work any jobs, right? So you get an idea, you know, and sometimes I get a question, well, what about Hollywood? Don't they have little people actors that are working all kinds of hours on a movie set or a television, yeah, there are certain exceptions to the rule. And yes, you could have a little kid working on a movie set for 10 hours, even though the requirement is that you could only work a couple of hours. But in order to do that, you have to accommodate that little individual by providing on-site educational services and so on and so forth, and you have to kind of take the basic protections. But generally speaking, these are the rules with respect to young people working. Yes? It depends partly on the industry, and I don't know, but let's say it's not the movie industry, or it's not some kind of a performance industry. For any typical kind of a job, for example, how long can someone work at a grocery store? Usually, I don't quote me, but under the age of 16, I think it's no more than 10 or 15 hours or something like that. So it's it's putting, and again, the idea is balancing education with work, essentially. So there are bright line rules in terms of if you're outside of these sort of performance industries, how much can a child work in those jobs? All right. So the Fair Labor Standards Act also regulates minimum wage, right? So what they basically say under the Fair Labor Standards Act, and mind you, when the law was enacted way back in the 1930s, it didn't set a dollar limit, right? It set the minimum wage at whatever the living wage was back in those days, and then it's subject to adjustment. This is, one of the topics that I assigned for an assignment last year was minimum wage. There was a lot of push to increasing the federal minimum wage, and we see this a lot. It hasn't been raised in quite a while at the federal level, because what the federal minimum wage does is sets a minimum, a nationwide minimum. Number of states go above and beyond that. New Jersey is one of them, New York is one of them. I mean, states where the cost of living is quite a bit higher than it is in other parts of the country simply go and raise their minimum wage a couple of dollars more. But there's, almost always a national debate about whether or not there should be a nationwide huge jump, because, the minimum wage isn't a heck of a lot. It's $7 and change, right? Which, even if you work a 40-hour work week, doesn't give most people a living standard that they can live at. But let me just give you the other side. The other side is businesses, right? What is the cost of doing business? I mean, how does a smaller business even survive? Will it lead to even more job cuts and so on? That's always been the debate. And again, people fall on both sides of the issues here and so on and so forth. Our job is really just to understand that there is a federal minimum wage. You can't legally hire someone and pay them less than the federal wage. And if you happen to have operations in a state where the state, like New Jersey, has a somewhat higher 8 and something, you have to pay those employees in New Jersey the higher state wage, right? Because when federal and state law do not match up, to the extent that they don't conflict, the state law prevails over that, right? So you would pay New Jersey employees more here. There are certain people that you can pay a little less. For example, students, apprentices, someone who's learning a trade can be paid a little bit more because you're providing training to that individual. But generally speaking, I mean, people who work in the restaurant industry, there's an expectation that they will have gratuity or tips, can sometimes get paid a little bit less than minimum wage because their overall wages would work out and so on. But generally speaking, you have to pay at least minimum wage as an employer. And now, the last part of the Federal Labor Standards Act, you also have to pay certain employees time and a half for every hour that they work beyond the normal 40-hour work week. So if you're asking employers to work 45 hours for a particular week, and you're paying them at minimum wage, and let me just sort of say minimum wage is $10, it's not, but let's just say it is, then for those extra 5 hours, you have to pay them what? 15, time and a half. I don't know about you, but most of us work more than 40 hours a week for the same employer. Is everyone entitled to overtime pay? Sadly, no, because the federal law defines employees as either exempt or non-exempt. Exempt means that they're exempt from overtime. Non-exempt means that they're not exempt from overtime, and the employer has to define its workforce. And the rules basically say that certain categories of employees are just exempt: managerial, supervisory, so, all kinds of categories. But if you're basically a salaried employee, so if you're making X dollars per year, yeah, during tax season you're going to work more. Don't expect that to be a time and a half. Sorry, guys. But certain categories of employees are non-exempt, meaning they're usually hourly employees, right? So if someone is hired to do X number of hours and they're paid at that hourly rate, it's kind of hard to make the argument that they are exempt. Those are the types of the employees, and usually it's lower skilled hourly employees that have to be paid that time and a half. And employers sort of, to manage their liability and their financial constraints will not give overtime, will schedule employees to work less than 40 hours because they know that for every hour beyond the 40, they're going to have to pay time and a half for that. The case in this chapter was kind of an interesting case. It was brought under the Fair Labor Standards Act, and it went all the way up to the U.S. Supreme Court in 2005, and this was the Alvarez case. And it involved a meat packing plant as the employer. What was the issue in this case? All the way up to the Supreme Court. What seemed like an issue that really should have been decided the way it was. Anyone else other than Kim that wants to tell me about the Alvarez case?
It's the time between the locker room.
Yeah.
And going to the production.
Right.
The main
Issue.
issue.
I like the way Michael cuts right to the chase. Yeah. So, employees are working and they're basically cutting and packing meat that's going to go to grocery stores, right? This is a meat packing plant. And the employer is saying, we will pay you from the time you first start packing to the time that you have finished packing your last bag, right? That is the time. So if the clock starts from when you first start, and the clock ends from when you start packing your last one. Well, the employees are saying, but wait a minute. When I show up to work, I can't just go to my station. I have to go to the locker room. I'm required under safety standards to wear this to protection material. So that takes, I don't know, make up a number, 15, 20 minutes, right? And then when I finish doing that, I can't just walk out. I've got to go back to the locker room, take off all of this stuff, put it back. I'm required to do that. Why am I not being compensated for that time? That's part of the time that I'm at work. I don't know, most reasonable people would say, yeah, makes sense. But this case was litigated, and the Supreme Court fortunately said, yeah, that does make sense. The time that you're spending going to the locker room, changing, coming back, is all time that is compensable. And now, again, this is, workers legitimately asking to be paid, and employers saying, wait a minute, this is going to cost a lot of money. We haven't figured that in. I mean, if that happens, then, I'm paying every employee an extra hour a day. Hour a day translates into however much. And by the way, this is setting a standard not just for this industry, but for any industry, right? Supreme Court cases precedent. So forget meatpacking. It could be anything. It could be a factory worker that needs to don a certain outfit. It could be someone who works at a nuclear plant, right, that needs to wear safety equipment. It applies across the board. But again, it's a rational decision. That it's not, when the clock starts really depends on what is required for your job. So it doesn't include the time that you walk in and have to stop at Dunkin' Donuts to get a cup of coffee because that's what you need in order to work. But again, we're talking about legitimately what is required of your job. And I think it's hard to argue with a straight face that the safety equipment that someone needs to put on shouldn't count as part of when their job day begins. Slide number 15, sorry again, we don't have the visual, again talks about what are the exemptions from minimum wage and overtime. And as I said, executives, administrative employees, learned professionals, someone with advanced degrees, highly compensated employees. And these are all terms of art. I mean, every year the law defines what is a quote-unquote highly compensated employee. Right? And it's just, you started with a number like 70,000 or 80,000, it goes up every year. And today, a highly compensated employee is someone who makes, well over 120, 130,000. You don't expect those kind of people to get overtime, right? But people that make far less than highly compensated employees could fall into this category. If you're an administrative employee, if you're making a salary, a fixed salary of $50,000 a year, you leave early, but you don't clock in, you don't clock out, you're going to be exempt. You're not going to get overtime, right? So again, there are standards by which the employer has to qualify its workforce as being exempt or non-exempt, and to the extent that someone is non-exempt, they are entitled to overtime. Questions so far? Let's keep marching on yet more employment-related rules. Slide 16. I'm now up to Family and Medical Leave Act, the FMLA. Everyone heard of it? Yes, please. Okay, I am being put to the test today, aren't I? So give me an example of a, where am I? Yeah, there's an example of certain, computer employees sort of, when you talk about like the software industry, the intellectual property kind of industry, the Department of Labor has created different categories. And the idea here is that these group of individuals don't necessarily fall into always learned professionals, because that we think of someone that has a PhD or someone who's got a very advanced degree. A lot of very skilled computer guys or gals could just have a certification. But boy, that certification really gives them very, very skilled jobs that they can do. So the Department of Labor created this category to allow employers to classify a lot of these software people, even though they may not have conventional college degrees, but they have these very coveted Oracle and that kind of certification as being non-exempt. Sure. Good question. All right, everyone heard of family and medical leave? And we know this because for the last several years this has been the law of the land, and it's actually served a very nice. Take a guess, when was Family and Medical Leave Act enacted? Okay, good guess. I feel like the price is right. Lower, higher. Anyone else? 1998. Closer. All right, it was in the 90s. It was 1993. And that surprises a lot of people. When we think about the Fair Labor Standards Act way back in the 1930s, and let's just talk about what Family and Medical Leave Act is, and we only just celebrated the 20-year anniversary. It isn't that old, and it caused a huge debate in Congress as to whether or not the sky was going to fall. Requiring employers to do this, oh my God. Well, what is the FMLA? The FMLA guarantees workers, I wish I had the slides out, because I would just point at that word. What does it guarantee workers? Unpaid time off, not paid, unpaid time off from work for family and medical emergencies. Who does it apply to? And there was a lot of debate over should it apply to all employers. No, it would be too much to have it apply to a 10-person employer, because what do they do if they have to give time off? So the law is basically it applies to companies with 50 or more employees, so a bit more of a larger employer. And in order for an employee to even get FMLA, they have to have worked for the employer for at least 1 year. How much leave can someone get per year? Very good, it's 12 weeks. Does that leave have to be continuous, or can you take it over time? You can definitely take it over time. But come back to unpaid. If it's unpaid, what's the big deal? What are you really giving employees? What is the point of the FMLA? Job security. You cannot be let go during that time. The employer has to buck up and accommodate you, right? So, if you're and who do you take leave for? Well, it says you're allowed to take up to 12 weeks for what? Usually it's for the birth of a child, or if you've adopted a child. So does that mean it applies only to women? It actually does apply to men as well, because yes, women may give birth, but after that, the real work begins, which is you have to raise the child, right? So indeed, Parents can apply for family and medical leave for that reason. What else? Serious health condition of the employee or spouse, child, or parents. And when I was in private practice and I work in the employment area, one of the things that surprised a lot of people was grandparents. If I'm a grandparent, which fortunately I'm not, will hope to one day, can I take time off to care for my grandchild? Not under the FMLA. And that's because, you have to kind of look to see what, and again, the law is always a compromise. Yes. Yes, okay. If you are the legal guardian as tantamount to a parent, good point. But if I just want to help out my daughter, I can't do that. It's if I'm not the recognized guardian of that child. And that's, what's that? Legal guardian, exactly. So, if I just want to help out a family member, the relationship here has to be spouse, child, or parent, and it ends there. So, yes, it is a very powerful protection. But remember, it's unpaid. The employer does not have to pay you. You could use up your vacation time and your sick time and all of that, but beyond that, it could be unpaid leave. But what it gives employees is the ability to not lose their job. And if they took, let's say, 2 months off, that they don't come back and the employer doesn't say, well, we had to give you the leave, we did, but we're demoting you. Can't do that because you have to restore the position that they were in or an equivalent position. Yes? No, no. You don't, yeah. You can choose to use your vacation, but you don't have to. Sometimes it depends on how a particular employer might run. Remember, personal time off, PTO is the employer's, right. But again, employer has to be very careful. You have to read the FMLA regulations quite carefully. You could structure your paid time off in a way that FMLA kind of eats into it first, but you still have to be very, very careful how you marry the two. Most employers will say it's your choice. But do you remember why they're making you do that? They're making you do that because, they're trying to see if you can limit the time away from the office. So when you run out of paid time off, it's unlikely that you will want to be on unpaid leave. Was there a question? Right. FMLA leave, they run them together. Yeah. That's typically how it's done. Yeah. And well, that's again state law. State can be you're mixing up disability. Under state law, New Jersey, I mean, don't quote me, but I think you're right. It is 6 weeks of paid leave, but it's running simultaneously with your FMLA. So let's say someone takes the maximum. They take 12 weeks, which is approximately 3 months, right? 6 of those weeks would be paid through the state disability, and the other 6 won't be, but after 12 weeks, you've exhausted your family and medical leave. Sure. So you're saying 24, and then the New Jersey 12 runs before you can even take FMLA? Okay. You can see that this area is far more complicated than, but I'm just curious. Yeah. It's not 6 weeks. Okay. Okay. Got it. And then FMLA. I'm more familiar with this rule of running, yeah. Yes. But you cannot run short-term disability at the same time that the FMLA clock ticks? Are you sure that is not a generous policy of your employer versus, yeah. Okay, I will look that up. I'm curious as well because. Correct. Okay, let me just put it this way. What if, and then we'll drop this. What if you start the leave from the time that the child is born? Yes, that's the point. That's the point. Oh, right. So you could take some leave before, but a lot of people choose not to do that. Right. Right. Yes, and I think that's a good point. I mean, we will always, FMLA starts from the birth or adoption, so you will have those 12 weeks. The question is, what if I start my leave? Right. Right. Okay. More information than anyone ever needed to know about the FMLA. But the point here is that it's unpaid leave. It's 12 weeks. It applies to relatively large employers. And if you just joined a company, and again, it's not just maternity leave. It could be someone gets a horrendous diagnosis, or their loved one gets a horrendous diagnosis. It involves chemo. It involves going back and forth to doctors and so on. That's what it was intended to also do. So it wasn't just designed for maternity, which a lot of states' law already had, but it was designed for the what-ifs of the world. And by the way, for those of you that are assigned the topic of paid leave, it kind of sort of, goes into the same issue of, do we go forward or do we go a step forward, or is FMLA enough? Is it enough pressure on businesses? Is it enough to balance the needs of workers and employers? And that's an open question. COBRA, the next law. It has nothing to do with a snake. And a lot of people say, well, where does COBRA come from? Where do these names of laws come from? Well, if you look at the name FMLA, you look at the name of the law, Family and Medical Leave Act, right? So COBRA comes from a budget law that was passed called the Consolidated Omnibus Budget Reconciliation Act, COBRA. So again, if you're on Jeopardy one day and someone comes up, you will be ready to answer the question. How long, before we talk about what COBRA is, how long has COBRA been around? Forever? 2000? 1990s? Further back? Take a guess. Very good. It was 1985, right? So it wasn't, again, not that long ago. But what does COBRA do? And this is another one that, people think, well, I'll get COBRA. Has anyone ever been on COBRA? Most of you are. Did you have? Yes. Okay. Unionized, but even non-unionized workforces have COBRA. Did you pay for COBRA? No. Because you're unionized, and they might have. Yeah. COBRA is continuation of medical benefits. Right? That's all it is. So it is given to terminated employees. And terminated, by the way, could be someone gets laid off, or I quit. I want to be, I want to go set up my own business. And during that time, I used to have health insurance from my employer, but now I don't. So what? It's not like unemployment. I can still get COBRA if I just quit. It's meant for terminated employees. And it's actually more than that. If someone gets a divorce, can their spouse continue on the medical insurance? They can get COBRA, right? So what is COBRA? It's basically giving employees and dependents the opportunity to continue their group health insurance. Sounds great. Sign me up. Who wouldn't want it, right? The problem is you got to pay for it. The employer, for the most part, is picking up a lot of the premiums that go towards that coverage. We all contribute as employees, but once you go on COBRA, you pay the entire thing. And that's the problem. Health insurance, COBRA costs. But what's the advantage? The advantage is that you get the rate that your employer was paying. And we all know that employers insure a lot of different employees. They get better rates from insurance companies. So the benefit for those people that go on COBRA is, first, they get to keep the coverage that they had. And two, they get to pay the employer prices, not the price that they would pay. Now, COBRA was a big deal. It still is kind of a big deal, but it was a bigger deal before the new Healthcare Reform Act came into place, right? Now, for the last couple of years, people can go and buy health insurance on these exchanges, right? And those, for most people, give a lot more options, affordable options, than COBRA, which is still available and still has to be offered. But a lot of people are saying no thank you to COBRA because my employer had very rich coverage, and I was glad to get it when they were paying 75% of the cost. But you know what? I don't have a job anymore, and I cannot pay 100% of what they were paying, but I can go on the exchange and I can get health insurance that is not as frilly and as generous, but I can get a better rate, and maybe I can even get a subsidy to pay for it under this new law. So, but COBRA is still important, and the employer's responsibility is still to offer it, to notify employees, to have the mechanism in place to continue to get premiums from those employees even if they're terminated. But it's used a lot less now since the exchanges under the Affordable Care Act have gone into effect. Okay, so again, FMLA, COBRA, great, but you're taking unpaid leave and you're paying for this coverage. It doesn't come at no cost. Real quickly, the next law we're going to talk about is ERISA, E-R-I-S-A. Where does that name come from? Employee Retirement Income Security Act, ERISA. Enacted, I won't make you guess, but we're going back in one more decade. It was enacted in 1974. Why? What is it? Well, this is basically a law that oversees pension, 401k, and health benefits. Employers don't have to give you any of these things. They don't have to give people pensions. They don't have to give them 401k plans. They don't have to give them health insurance and all of that. But they choose to. A lot of them still choose to because it makes them competitive. It's the right thing to do. We're just, it's expected in the marketplace and so on. But the problem was, and the reason why ERISA was enacted, was employers were not, back in the day when people used to get pensions, they were not funding them, right? And if you're not funding them, employers have an expectation, but when the company goes belly up, there are no pension benefits, there's no fund to pay out of. There was no, people were being fired just right before they came into their pension benefits, they're not vesting and so on and so forth. There were a lot of abuses, right? So that's what the 1974 Act, ERISA, was designed to prevent. And today, there's a whole compliance structure to, very few employers today have pension plans, but some do, depending on the industry. A lot of unions still have pension plans, automobile industry, some do. Most employers have 401k plans, right? But what kind of funds do you put in? When does an employee vest? How does a match vest? All of those rules are under ERISA. Same thing with health insurance, right? If an employer is not buying an insurance policy, but they're actually a large employer that is self-insuring, what are the rules with respect to funding those health insurance benefits? All of that comes under this law known as ERISA. And again, I say employers don't have to, but the vast majority of them do this voluntarily, and in doing so, they have a huge compliance obligation with respect to the employee benefits that they offer. So you start to get a picture that, employment law is an area unto itself, and employers have a bunch of different laws that they're juggling in addition to running their operations. Let's talk now, starting at slide 20, about some of the government programs that are out there. Unemployment insurance, right? I won't ask who's ever collected unemployment, but it happens. We've had a downturn in the economy. And unemployment insurance is designed to basically provide some resources to individuals when they become temporarily unemployed. And we saw with the big recession, 2007, 2008, that these benefits were extended far beyond the time frame that they usually it's 26 weeks, but it went much more because of the economy, and that took federal action. But again, this is something that one doesn't get for saying, I quit. It's something that one gets if they are let go of for reasons that don't involve fraud or things like that. And who compensates, where does the money come from? Again, employers pay an unemployment tax, right? I mean, it's taken out of the if you pay wages to someone, you also have to pay a percentage into a state unemployment compensation fund. And this is a fund that is available to everybody to the extent that someone becomes temporarily unemployed. Another government program that we hope will be around by the time most of us are ready to collect is Social Security. And Social Security has two components, right? It is income that someone gets through a big insurance program that the government runs when they reach a certain age, and it's health benefits. It's Medicare that someone gets starting at age 65. We all know that the money has to come from somewhere to fund these programs, and it's been coming from, look at your paycheck. And you'll see that the biggest component is the money that it's taken out for Social Security, FICA, and OASDI, which is the Medicare component. It's about roughly 8-point-something% out of everybody's paycheck. The employer has to match it. The employer, let's say somebody has a $100,000 job. You're paying $8,000 a year. Your employer has to pay the same amount to go to the government. And the government is funding Medicare and Social Security out of these monies. What's the problem with Medicare and Social Security that we hear? They might run out because they're using today's dollars to pay out benefits. What about later, right? So, it depends on who you talk to. The economists, some people will say the sky is not falling, it's not that bad. Some people say it might be just that bad. Again, this is a fascinating topic. But the point here is that, it becomes a big political issue. No one is in favor of abolishing it, but no one is in favor of paying more taxes to keep it solvent. So we just kind of keep griping about it, because how do you fix a system where the population is living longer and longer and healthcare costs are increasing higher and higher? Exactly, and trying, but that's not a good political scene to make that happen. And the other thing that they're trying to do, and this affects all of us in this room, is the retirement age to collect Social Security keeps going up, right? Depending on when your birthday is, don't think it's 62 or 65 anymore. It's 67, it's 68, it might even become 70. Why? The idea is the later someone can collect, the less money the government has to pay out. There's also talk over the years about privatizing Social Security. Why not have people invest? And again, the problem there is this is money that's managed at a low rate of return with fixed income type things. What if we let people just go crazy like they did with their 401k plans? What's going to be left? The idea was this was never intended to be play money. It was intended to be kind of like supplementary income that is a sure thing. So again, we could have a whole class about Social Security, but it's an interesting program. But it is, the reason I bring it up with the employment law chapter is employers are required to deduct the money and pay an equal amount to the government. So, what does it cost to hire an employee? Not just their wages, but the various taxes, the Social Security contributions, the health benefits, the COBRA costs, all of this sort of plays into the cost of hiring an employee. Okay. What's that again? FICA, and I know the acronym, it's OASDI, it's old age something, I forget what it stands for. So, like if it's 8.6%, 7 point something is FICA, 1 point something, it's called a Medicare tax, basically. All right, the last thing I'm going to just quickly talk about is immigration law, right? Employers are required to verify the legal status of an individual that works for them, meaning do they have legal status to work in this country. And someone could be a citizen or a naturalized citizen, no issue, but someone could have a special type of a visa, right? And please don't memorize this, but H1, I keep pointing, H1 visas, EB visas, people that have a short-term visa to work in this country because they have the type of skills that we want to have represented. But if any of you have ever applied for a job, You'll fill out all kinds of forms, and one of the forms you'll fill out is something called an I-9, which basically says, show us that you have the legal right, and we're going to keep records because if the government comes and does an audit, we have to prove it to them. So again, that's just another obligation that employers have to abide by immigration laws.